We are going to now today try and work a little on the case study which has been provided. I hope all of you have had the opportunity to go through this case study and be a little prepared so that we can have a little bit of an interactive session. So what I plan to do today is, first of all, try and frame the issues in the CAPA case that we have. Okay, before we begin, I just want to mention that this case study material is adapted with permission from the material developed by the International Advocacy Training Council. So I must give credit to them. It is adapted with permission from them. So let us start with the issues. So does anyone want to tell me what the issues in this matter could be? What is asserted by one side and what is denied by the other would be an issue. So what could be the issues in this matter? Now, someone has said negligence. Negligence, yes. Negligence is the cause of action in this matter. So what would be the issue? Could the issue be, was there negligence on the part of the opposite party? Would that be an issue? Because the applicant is claiming that there is negligence and the opposite party is denying it, right? So was there negligence on the part? Does anyone want to tell me what would be the elements of negligence? When can it be said that one person has been negligent in respect to another person?
So, Sneha, I think when there is a duty of care that is owed by one party to the other party, and there's a breach of that duty of care, and this breach has caused harm. So, these are like the three essentials of negligence.
Right. So, it would be whether there is a duty of care, whether there is a breach of that duty of care, and then whether the plaintiff is entitled to damages would depend on whether, on account of that breach of duty of care, there was damage caused, right? So when we have this issue of was there negligence on the part of the opposite party, we could either have this broad issue, which would within it contain two issues. So we could either have one issue or we have two issues. Was there a duty of care on the part of the opposite party? And two, was there a breach of this duty of care? And then, of course, as Karunya said, the next issue would be, did the opposite party's action cause damage to the applicant, right? First of all, there was negligence. If we prove that there was negligence, did that negligence cause damage, right? And what would be the final issue, anyone?
The loss should not be too remote.
Yes, that is one of the aspects of the second issue, isn't it? That did the opposite party's action cause damage to the applicant? That it should not be too remote, correct? But what is the relief which is claimed in this? He has claimed monetary relief, right? The applicant. So therefore, would the issue be, is the applicant entitled to the damages that he has claimed, right? So then he will have to prove the amount. He will have to prove that he has suffered this damage and this is the amount and he's entitled to that, right? So that would be the third issue.
The proximate cause.
Yeah, correct. So is the applicant entitled to the damages that he has claimed? He has claimed some 7 lakhs, right, in the case. So, right, so these would be broadly the issues. Now, what I'd like to do is, if we can identify from the pleadings and the evidence, what are the facts which are in favor of the applicant and what are the facts which are in favor of the opposite party? If we can kind of try and do that, that will help us to analyze the case, right? Okay, so I'd need facts helpful to the applicant from you. Let us just try. We've gone through the case study. There is no right or wrong answer. We're just trying to understand here. So what are the facts helpful to the applicant?
So the first one may be the fact that the respondent may have been on his phone or while driving. So he may not have been paying attention.
So opposite party was on the mobile phone while driving. Okay. Then something which is helpful to the opposite party. Yeah, so Kumar Aryan is saying seatbelt. Okay, so facts helpful to the opposite party is that the applicant was not wearing a seatbelt. Another fact, anything either helpful to the applicant or helpful to the opposite party.
The applicant, so helpful to the respondent, the applicant was bent over in his seat. He was not paying attention to the road.
The applicant was not paying attention.
Yeah.
So someone has said witness also claimed that opposition party was not on his phone. So that is a fact helpful to the opposite party.
The applicant has mentioned that initially between the brawl, the opposite party didn't deny using the phone.
Yeah. So that is a fact helpful to the applicant. Opposite party did not deny using the phone. when the applicant accused him of doing so, right? The opposite party was driving too fast. Yes, that is a fact which is helpful to the applicant. Then we have opposite party didn't sound his horn, correct? Opposite party did not give way to the applicant, right? Anything related to Ravindran which could be helpful to the applicant? Anyone thinks? Does anyone think that something related to Ravindran helps the applicant? Ravindran is the witness of the opposite party. Yeah, Ravindran said that the respondent was not using the phone is against the applicant, right? Something which is in favor of the applicant, something to do with the with Ravindran.
The possibility that Ravindran affirmed the map drawn out by the applicant, which shows that the respondent, even though he was going towards the exit, he was not really moving towards the exit. Because for the exit, he ought to have taken a right, but he went straight and stopped. So essentially, he may also not have been paying attention to the road or the road signs in the parking lot to move towards the exit.
Okay. That Ravindran confirmed the map drawn by the applicant. Okay.
Initially, Ravindran states that he observed the accident, but simultaneously, in his next statement, the certainty of it is discarded, and he's not certain whether he actually saw the whole incident from the very beginning.
Okay.
But rather, he was.
Can we just open Ravindran's affidavit?
Yeah, there's one more observation that the applicant was injured.
Yes, the applicant was injured. Now let us look at Ravindran's affidavit for a minute. If we say paragraph 2, what does he say?
Mr. Ravindran claims that he saw the accident at the area only after the accident. At the same time, he is sure that the respondent was not using the phone, which is a bit contradictory because the respondent must be using the phone before the accident and he observed the area only after the accident, after the sound or after the collision.
Absolutely. So, Ravindran, what is relevant is whether the opposite party was using the phone when he was driving, when the accident occurred, right? And Ravindran says that he saw the car only after the accident occurred. So he could not know whether the opposite party was using the phone or not when the accident occurred. He could not have known at all. So therefore, what Ravindran said that the opposite party was not using the phone would be hearsay because he has no personal knowledge of this. He had no way of knowing because he himself says that I saw the car only after I heard the crash. Ravindran says that Bhatia behaved very well. Yeah, that may be a fact in Bhatia's favor.
It is not shown on the map in which direction the defendant's car is going, whether it is following the arrows or not, because then that would be helpful.
Actually, if you see, the map also kind of suggests that the defendant was going in the wrong direction, because if you see the map, which is annexed to the affidavit of the applicant, you will see that the exit is straight ahead and the defendant is actually going in the wrong direction, right? So that is also a fact which is in favor of the applicant. So basically what we're trying to do is we're trying to understand what are the facts on each side and then ultimately decide on how to go about with the evidence, right? Let us now try and see if we can identify, we have the affidavits of evidence of all the 4 witnesses, right? So let us now see if we can identify on what aspects those particular witnesses can be cross-examined. So let us look at first, what is his name? Deepak Kamal Singh. Deepak Kamal Singh. Now, what could be the points on which Deepak Kamal Singh could probably be cross-examined? If you see his affidavit of evidence, what are the points which you can try to achieve from his cross-examination?
So by proving that he was having a discussion with John Raj about what they had just purchased, or that John Raj was showing the applicant something that they had just purchased, you could prove that the applicant was not paying attention to the road.
So the aim is to prove that the applicant was not paying attention. That is one aim we can try and prove by his cross.
I think another thing that you can prove is that the applicant didn't take sufficient care because he was not wearing a seat belt. He was not focused on the road. So he himself didn't take sufficient care. Had he been wearing a seat belt, he may not have been that injured.
Okay,
like he may
so
not
now,
have suffered a head wound.
Is this a fact which we need to bring out from his cross-examination, do you think?
Maybe to
Because-
reduce the amount of damages, if at all payable.
Because if you see his evidence, he himself says that he has not worn a seatbelt. So we don't need to get that really out through cross-examination because it's already admitted by him, right? So that may not be one of the aims of cross-examination of the applicant. But maybe, I don't know, if we could ask him some questions whereby we are able to show that because he was not wearing a seatbelt, he was injured. Maybe that could be a point. What are the other aims we could have? So we can maybe probably say that the applicant was injured because he was not wearing a seatbelt. Can we get something like that? Anything else?
Yes, ma'am. He
Yes.
says in the affidavit that he is in a private area, not on the public road, so he need not wear the seatbelt and he is within his rights to not wear it.
Yeah, that is correct. That is correct. But the point is that if he had worn a seatbelt, would he have been injured or not, right? So if we can try and show that. Now, one is this fact about whether he was bound to wear a seatbelt or not is relevant to the fact as to whether he was following the law or not. And that we need not really cross-examine him on, right? If the law requires that he is not, that he is to wear a seatbelt in the parking lot, then we can show that law, we can show the relevant regulations or the rules, whatever it is. If the law doesn't require it, it doesn't require it. So we may not really need to get this from him in cross-examination. But whether he was required to wear the seatbelt or not, if he had worn the seatbelt, maybe he wouldn't have been injured, right? So if that would definitely, it may not be something conclusive if he was not required to wear the seatbelt in the parking lot, but it would be something in favor of the opposite party, right? That if he had worn a seatbelt, if he had been careful, then he wouldn't have got injured. Could it be that, could we try and get from him that he should have stopped as soon as he saw the car approaching? Because he says, I saw the car approaching. But instead of stopping, he turns to the left. So Bhatia's, the other side's car has not hit his car. It is his own action of turning left. If he had stopped, probably the accident wouldn't have occurred. So maybe we can try and get that from him.
Okay, so there is one participant saying that since the vehicle was not in his control, means that proves that the applicant too was speeding.
Yes. So then, do we want to say, do we want to try and prove that he was speeding? That would be another aim.
Actually, the comment is that the opposite party failed to properly control his vehicle, not the applicant. So it was not the applicant who was speeding.
Okay.
This is more a point to the opposite party.
Yeah. So if we are trying to look for an aim of cross-examination of the plaintiff or the applicant, then we have to get something in favor of the opposite party, right? So what are we trying to say here? That the applicant was speeding. If we can try and get that from his cross-examination, it will help the opposite party. Okay, now let's go to John Raj. What has John Raj said in his evidence and what can we aim to cross-examine him on? Can we decide on that?
Ma'am, Mr. John Raj has said that he was explaining about some commodities which he had bought from the mall to the applicant. So this can be that there is a point can be noted that both of them were conversating and there is a chance that applicant was not paying the complete attention towards his driving. Instead that he was indulged in a conversation while they were driving the car.
So that the applicant was not paying attention, maybe we can get from the evidence of John Raj.
Yes, in para 2, in fact, he starts off only by saying that I did not pay a great deal of attention, I'm a nervous driver, and his entire mindset was to distract himself. So honestly, that really makes him a very poor witness in that sense because he wasn't focused at all.
So there are two things we can do from John Raj's evidence. One, show that the applicant was not paying attention, and two, that John Raj himself didn't see the accident.
Correct.
Okay. Anything else from John Raj's evidence?
Ma'am, John Raj was worried that he made the applicant late since they had spent more time than they had intended. And secondly, John Raj didn't certainly state that he did see the applicant using the phone, but only ascertained the bent of the opposite party's head and the right hand.
Yeah. Are we trying to say that John Raj is implying from his evidence that the applicant was a little angry, right? So can we try and get that out from his evidence that the applicant was angry? He was not in a frame of mind, so which is why he was disturbed while he was driving. Maybe that could be something in favor of the other side, that the applicant was angry.
In fact, he says so at para 3. If you look at the second sentence, he says itself that I got the impression that he was not really listening to what I was saying. And he suddenly said something to me like idiot. So that shows that he just flew off in a rage.
He was not in a good frame of mind.
Yeah. And that also helps the fact that he probably didn't have control over his vehicle, because then you can say that he has road rage, he's temperamental. So he himself was responsible for suddenly swerving and, sort of causing his own accident.
Yes. Okay, then let's try and move to the other side now, opposite party. Vikram Kumar Bhatia.
I just wanted to mention one point about the applicant.
Yes.
He stated in his affidavit that he got down of the car and remonstrated politely with the other person.
Right.
We see that the witness of the applicant himself and the Ravindran, I guess, who was present there, both of them said that he was yelling and he was
Correct.
shouting at the other person.
Correct.
So can we attack the veracity of this person as a witness and say that he is lying? And so since he has lied in this point, he is not a credible witness himself. So
we can try and make that point, but not just because a person has lied at a particular, it will of course affect his credibility, but he may be lying about a particular point, but not necessarily that he's lying about everything that he's saying. So but yes, of course, it would affect his credibility, and we can say that. In the final arguments, that would be something which could be said, that his own witness was saying that he was angry and he went and he was shouting, and he said that I was demonstrating politely. So certainly it's a good point, it's a point in favor of the opposite party. Now, if we look at some aims of cross-examination of Vikram Kumar Bhatia, if we look at the evidence of Vikram Kumar Bhatia, what would be the aim of cross-examining him? If you look at his affidavit, what could be the aim of cross-examining Vikram Kumar Bhatia? What can we try and bring out in his cross-examination? Was using the phone. Yeah, maybe we can try and do that.
Ma'am, the opposite party was using the phone and he was not fully focused on driving.
And in para 5, he says himself that he saw the other car, and then in para 5 he says, I thought I could just get across before he emerged into my traffic lane. So that can prove that, probably because the car, he took his car all of a sudden, that is what caused the applicant to sort of swerve suddenly and
he should have stopped instead of speeding.
Yes, and he should have sounded his horn instead of, trying to cut across in a hurry, essentially. Because he also accepts that I quickly accelerated for a few seconds, and that's more than enough, because we all know that in a car parking lot, it's a rather narrow space.
Yes. So that he should have stopped instead of accelerating, that we can try to find out.
Yeah.
Okay. Can we try and get him to admit that he was going in the wrong direction?
Ma'am, we can try that. Even he has admitted that he was late for a client's meeting. That point should also be noted, whether the late due to which he can accelerate his car and the negligence can occur.
Yeah, so that is something which we can probably try and argue, that he himself has said that he was late. Then we try and get him to admit that he was going in the wrong direction. We can show that instead of stopping, he accelerated and that was because he was getting late. And that is what caused the accident, right? So here maybe we can try and show that he was going in the wrong direction. Now, let's look at the last witness, Ravindran.
Ma'am, the opposite party has said that he saw the car of the applicant coming from the left side. So if he's saying that he saw it coming from the left side, then it matches with the correct way of going for the defendant's car. Because if he says the left, then he's following the arrow. We can say that. So how can we say that it was coming from the wrong direction?
Can you see the map, the diagram which has been drawn by Deepak Kamal Singh in his affidavit? So if you look at that, you just see where the exit is, all right? So this is very important, especially when there are maps. The exit is in one direction and the defendant is going in the wrong direction. So we kind of try and get him to admit that. Instead of going straight, he should have turned to the right and gone towards the exit. Okay, now Ravindran, I think Ravindran, we already discussed that he saw the accident only after it occurred. So if we can get that, then his evidence is completely hearsay. It doesn't matter what he says. So the point of doing this exercise is that once you get the affidavit of evidence in examination in chief of a witness, you need to study it and understand what you need to get out from that witness. Once you have those aims clear in your head, that is when you can kind of frame your questions and ask them accordingly. So now we have about 15 minutes. Would any of you like to try and cross-examine any witness? So because I've requested some people to act as witnesses, so would anyone like to try and cross-examine any of the 4 witnesses?
Yeah, I can try cross-examining anyway. I feel the applicant.
The applicant. Okay. So Sarthak, what I'm going to do is when you cross-examine, no, I'm just going to write down the questions that you ask. Okay. So that then we can see, can do something about maybe we can ask the questions in a different manner, or you ask them perfectly.
Okay.
Yeah, Pratik.
Yes, ma'am.
Yeah, so I have requested Pratik to act as the applicant.
Mr. Singh.
Yeah, so he will be the witness and Sarthak will cross-examine. Yeah? Yes.
Okay.
Yes. Can you start?
Okay. Mr. Singh, would you tell us what time did you reach the mall?
I'll have to exact time I'll have to go through. I don't have that thing open on my. Wait, I'll just be.
Would you tell us how much time you were in the mall?
About an hour.
Okay. Will I be correct in saying that? Would you agree with the statement made by John Rai in his affidavit that you were running late?
Yes.
Okay. Looking at the diagram in the parking lot, which direction were your car was parked in?
It was towards the mall. I mean the main entrance, and I was going towards the exit, which is a straight drive.
The first point I was going to prove was that it was said in the affidavit of John Rai that they were running late. That was one thing which assured me that they were speeding. So I was going to ask them questions that they were in a hurry and they were speeding. Like how much time they spent in the mall, were they in a rush to go home, were they exhausted? And secondly, I was going to ask which direction where the car was coming from, and when they were passing through the middle, at what speed, not directly, obviously, but how much speed would they be driving at? So that was my second point of questioning.
So there were, just if I can make one point, there were 2 questions which you asked. You said, would you agree with the statement made by John Raj that you were running late? And you also said, looking at the diagram or looking at the parking lot, which direction was your car going in, right? So I would maybe avoid these kind of questions for the reason that they are open-ended. So when you say, would you agree with the statement made by John Raj that you were running late? Here your witness, luckily for you, said yes. Suppose he had said no. You're giving him
that would have been a dark territory.
Correct. Right? Yeah. So always think about what are the answers which he could have given. He could have said yes, he could have said no. If he had said no and it would have hurt you, please don't ask that question. Right? So you don't ask that. Then again you say, looking at the parking lot, which direction was your car going in? Rather than, asking him a question like this and kind of giving him the chance to say whatever he wants, you can show him the diagram and put it to him what direction the car was going in and make him agree to that. So he has himself produced that diagram, right? So you can say that, please look at this diagram. Isn't it correct that you are going in so-and-so direction? So then he'll admit that.
Okay.
I'd like to cross-examine Mr. Bhatia, the opposite party.
Okay. So Karuta is going to play the role of Mr. Bhatia.
Yeah.
And Pavan is going to cross-examine Mr. Bhatia.
Basically, I just want to tell you that I want to ask the question first that, Mr. Bhatia, you said that you were driving slowly, but then you suddenly accelerated your car. So can you please tell us why you accelerated your car instead of stopping it?
Yeah, so I was driving my car slowly and I saw that from my left-hand side, Mr. Singh was driving and he didn't see me only. And because he didn't see me, I thought that I'm going to be able to cross quickly. So I sped up just for a few seconds to cross over so that we didn't collide. Because if I had continued in that speed, I think we would have collided. And because he didn't see, he wasn't looking at the road, he was looking at something else. He was completely not aware of what is happening. I didn't want to be in the situation where, there is a sort of car crash. Already I was running late, so I thought, if I speed up, it will be fine. And the applicant's car did not crash into my car. The applicant's car crashed because of his own.
Yes. That we are aware of. So I wanted to, Mr. Bhatia, then you were going out of the car park, and if we see from the map, the exit is on the right side from where you are coming. Then instead of going right, why did you cross over straight?
Because there's a longer route to take to the exit. So I thought instead of going right and crashing into the applicant's car, Mr. Singh's car, which would inevitably have happened because he was not looking at the road. I thought if I go straight and take the longer route to the exit, at least my car would be safe. And my car was safe because if I'd taken right, I would have merged into the same lane that he was in. And that would definitely have resulted in a crash because you can't take a turn at a speed. You can go straight at speed. But I would not have been able to avoid his car had I taken the turn towards the right.
Okay. So in your estimation, it was better to accelerate your car than to stop it.
Yes, I thought I'd be able to get past. I did get past actually.
And also, you in this all this while you could clearly see while you were driving, you could clearly see that the Honda City driver was not wearing his seat belt and he was bent over his seat. All that information you could gather while looking at the car and accelerating instead of stopping the car.
He was wearing a light shirt. You can see that kala seat belt that was clearly not there. And you could see that he's not looking at the road, he's looking somewhere else.
But you were talking on the phone, Mr. Bhatia. You mentioned that you had the phone in your hand. You were talking on the phone.
I was not talking on the phone. I in fact just cut the call before starting my car, like driving out of my parking brake. I was not
the
on
phone. The phone was in your hand.
The phone was there.
The phone was in your hand. You mentioned here that your phone was in your hand.
It may have been in my hand.
You said.
I'm sure I put it down, but it
in
may
your
have been.
point number 6, you say that when I was holding in my hand because I needed to ring to my client, the phone was in your hand. So you were only holding your steering with one hand.
No, I was holding the phone and the steering wheel, both hands.
Okay.
Thank you, Pawan. So there were 2 questions which you asked, which were why questions. You said that you were driving slowly, then you suddenly accelerated. Why did you do that instead of slowing down? And then you saw the effect of that. She immediately gave a long explanation. I did it because we would not collide, etc., etc., etc. And she actually gave an explanation for not slowing down and actually going fast, right? So really, these why questions are to be avoided in cross-examination because it gives a chance to the witness to explain. So you rather ask a leading question and lead the witness to the right answer rather than giving them these open-ended questions like why did you do so, and which gives them an opportunity to explain. Then again, if you see, you said you were going out of the car park. The map shows that the exit is to the right. Why did you go to the right? So then she again gave some explanation. I thought I could go in this direction, whatever. So rather than asking her the reason, you could have just maybe brought out that she went in the wrong direction instead of asking her what the reason was why she went, because that reason is really not even relevant to us, or it is relevant in the sense where we can deduce that she did it because she was not paying attention. But if you ask her, she is going to give you some big explanation, and that's going to really hurt your case, right? So let me maybe try and ask some questions to Mr. Bhatia and see if we can, probably try and get some answers. Mr. Bhatia, can you see paragraphs 6 and 7 of your affidavit of evidence? Here you say that you were late for an appointment. Would you stand by that?
Yes.
In paragraph 3 of your written statement, Mr. Bhatia, you say that the applicant was driving too fast. Do you stand by that, Mr. Bhatia?
Yes, he was not focused on the road, and so he was driving too fast.
The question is you said that he was driving too fast in the written statement. You stand by that. In your affidavit of evidence, Mr. Bhatia, you say that you were driving very slowly in the car park, correct?
Yes, initially.
Can we just see your evidence? Yes. So in paragraph 2, you say you say I was driving quite slowly, not only because I always do in car parks, but also I was getting close to the exit, right? You agree with that? Yeah. Now, according to you, you saw Mr. Singh not paying attention and bent over in his seat. Is that correct?
Yes.
Also, according to you in paragraph 5, you say that you realized that Mr. Singh had not seen you. Is that correct?
Yes.
So then, Mr. Bhatia, as per your own statement, according to you, Mr. Singh was driving too fast. He was not paying attention. He had not seen you, and you were driving slowly. In such a situation, Mr. Bhatia, you should have stopped, shouldn't you?
In retrospect, yes.
Or yes. Thank you. So here we have from the witness an answer saying that I should have stopped, right? Now again, I was lucky here that the witness has said yes. The witness could have said no, right? He could have said no. But then if you look at the questions which were asked before, and the witness has said yes to all those questions, if he finally says no to this conclusion, then it's going to look implausible. So the judge, even if he says no, so whether he says yes, if he says yes, then you win the jackpot, you've got the answer that you want. Even if he says no, it is still implausible. The judge is not going to believe him. So that is what we had discussed yesterday, that when you want to put a conclusion to the witness, you try and get him to agree to certain factual, non-controversial points, and then you build to that conclusion so that the only logical answer is yes.
Yes, could I cross-examine the applicant?
Yes, certainly, yes.
Okay.
Pratik?
Yes.
So, Mr. Singh, you say in your affidavit in para 5 that you have been driving for nearly 20 years and you regard yourself as exceptionally good driver. Okay. So, is it right to assume that you would know at what speed you should drive inside a car park?
Yes.
Do you know what that speed is?
It should be below 20-25. As it
Do you
wasn't
think it should be
mentioned, but
around
it is,
10-15?
depending on the curve. If there is a curve which is a straight path, then should be around 20, and if it is a curve, then should be below 10.
Okay, so at what speed were you driving?
I believe I was between 10 and 10 and 50.
So were your car in a good condition, good state of condition? All brakes were working, everything was fine?
Yes, yes, yes.
So since you say that you have been driving for 20 years, you know all this, and your brakes were working as well. Are you telling the court that at the speed of 15 to 20, you could not have brake stopped the car where it was and you had to take a rash turn and hit your car in the pillars? You think it is not possible? It is not possible
but
to...
there could be a car behind me. So I couldn't have immediately braked because the guy behind me would have collided. And all happened in a sudden that the only thing I could do was to turn left. That's why I turned left.
Okay, so you're telling the court that at the 50 or 20 speed, you could not have stopped your car where it was and you had to take a rash
there
turn.
was a car behind me. So the car behind me would have directly banged into my car. That's why I couldn't have braked immediately at that speed, even at that speed.
Okay.
Because there was a car immediately behind me.
Okay, so you said you could see the applicant on phone while he was driving. So, no, sorry, applicant, not the respondent. You could see him on phone while you were...
Yeah.
So you were aware that he was there. So he was coming towards you.
Yes.
Okay. So your speed was 15 or to 20. You saw the respondent coming your ways. You saw he was on phone. So as a good driver who has 20 years of experience, you knew he was not quite aware of you coming. So
I was aware of his speed, but I wasn't aware that he would accelerate suddenly.
Okay, so that's why you...
Yeah.
Okay. And also being an exceptionally good driver, you think it is not good to wear a seatbelt while you're driving?
I was about to post some letters at the end of the driveway. So I was going to get out of the car and it was not a public road. So I wasn't wearing a seatbelt.
So also you mentioned in your affidavit that you got down and you spoke to the respondent quite politely. Yes. But it seems that your own witness is saying that you were angry. What would you like to say about that? I mean, even the respondent said that you were angry. The respondent said that you were angry. Your own witness is saying that you were angry. But you're saying you spoke to him politely. What do you have to say about that?
I was polite, but as the witness knows and everyone, it is proved that I was injured. So my voice might have been raised at a point. So, but I was polite.
So
as
you're
per
saying
my assumption, yeah.
Okay, so you're
as per my statement, yeah.
Okay, so you're asking the court to believe that the three of the witnesses were the only witnesses there. All three of them were derelious, and you, who had just been in an accident, was quite right, and we should believe you. Is that your position?
A person is louder than usual when he is injured, but I was trying to be polite. I was polite, but I was injured and bleeding as it proved by the report. So I might be louder, but I was polite.
Okay. So thank you.
So Amaya, one good question that you asked was, you said that you could see the opposite party on the phone. So you were aware that he was coming towards you. So that was a leading question that you asked. And that was a good question because you did get the answer also. Then there was one question that you asked, at what speed were you driving? Again, that is a question which is a dangerous question because you don't know what he's going to say. So as we discussed yesterday, if you don't know the answer to the question, don't ask that question because he can say anything, right? So then again, you said being an exceptionally good driver, you felt that it was not good to wear a seatbelt. So then he started explaining. So maybe we could have asked him that being an experienced driver, would you agree that wearing a seatbelt generally helps to prevent injuries? Maybe something like that. So then he could have said yes, rather than, asking him directly about this, why he did not give a seat. So yeah, that's about it. Last, anybody wants to cross-examine Ravindran?
So, Mr. Ravindran, the first statement you have made that you were sure that Mr. Respondent was not using the phone. When did you see that whether the respondent was using the phone or not?
When did I see?
Yeah, you are sure that respondent wasn't using the phone.
Yes.
So how you came to that conclusion?
Well, I was in the car park and I was walking towards my own car. And at the time, because I heard the sound of the crash and it was so close by, I just turned and looked at once. And that's when I could see the situation of both the cars and drivers. And that's how I can confirm that Mr. Bhatia was in fact not on his phone.
But the negligence could be caused if the driver was using the phone 2 or 5 seconds ago the accident. But you were looking at you just saw at the incident only after the collision sound came to your ears. So how can you so sure about that Mr. Bhatia wasn't using his phone? Was that because of the explanation he gave you after the collision?
Well, of course, his explanation came second, but first was what I saw. And since, a parking lot is a rather small place, so as soon as the sound happens, you turn immediately. It's not like I'm far away. So because I'm close by, it's right in front of my eyes. It is plausible that, even if somebody's on the phone, for them to get off the phone and then come out of the car in a span of a few seconds is a little implausible. So that's how I can confirm that he wasn't on his phone, because I was right there and I saw it in front of my eyes.
You yourself were in the car park, so you might be a driver, a good driver of a car. So if a person is holding a phone, his phone in his hands, and he is coming out of his car, which Mr. Bhatia has himself affirmed in the affidavit, so how can he not be using the phone when he is coming out with the phone in his hands?
I'm sorry, Ayush, can you repeat the question, please?
Yeah, I can repeat. So Mr. Bhatia has said that he was having his phone in his hands. And at the time when the collision happened, he was about to ring one of his clients, which gives us a sign that he was about to use or he was using the phone. At the same time, you are telling that he wasn't, the phone wasn't with him, was not with him, and he wasn't using it. But he himself tells us that he was about to ring the client and the phone was in his hands.
I can't comment on that because I wasn't with him. I'm just a third person who saw what I saw, and no sooner I saw him, which was, I could say, immediately after the accident, he didn't have a phone.
Can you just please tell us that when Mr. Bhatia was interacting with you after the accident, whether he was having phone in his hands?
Whether he was interacting with me after the accident?
Yeah, after the whole event had occurred, after when you went to Mr. Bhatia and gave your phone number to him, whether he was having the phone in his hands or not.
Yes, after the whole thing, of course, because he was very calm and collected. So I offered, since I'm a nurse and I just saw the whole thing, I offered. I found him to be rather well behaved, and at the time, I gave the number. So that's when I saw that he had the phone in his hand.
Okay, ma'am. That's all.
Okay, great.
Okay, thank you, Ayush. Okay, so Ayush, what you did here is you actually gave the witness an opportunity to explain what she's not explained in her evidence. You gave her an opportunity to explain as to when she saw him using the phone, because you asked questions like, when did you see whether the respondent was using the phone or not? You said, how did you come to this conclusion? Was it because of the explanation that he gave you? So then she says, no, he told me and I also knew it, right? That was the answer. Then when Mr. Bhatia was interacting with after the event occurred, did he have the phone in his hand? That really may not even be relevant, no? Because what is relevant is whether during the course of the accident, he was using the phone, because that could be said to be negligence on his part. So what we are trying to establish here is that he didn't know because he didn't see the accident, right? We're trying to establish that. So let us see if we can try and establish that from what he has said in his evidence. So let me see if I can ask some questions to Mr. Ravindran. Okay, Mr. Ravindran,
yes.
Do you stand by your affidavit of evidence?
Yes.
Mr. Ravindran, you have said in your affidavit of evidence that your attention was drawn by the crash and that
Yes.
you then looked at the other car. Is
Yes.
that correct?
Yes.
So you saw Mr. Singh's car after it hit the railings, isn't it?
Yes, immediately after. I heard the sound and I turned and it was right there.
So it would be correct to say that you did not see the accident occurring, isn't that correct?
No, I disagree with that statement. I believe that because it was, like I explained earlier, it's a very confined space. And since I was right there, no sooner I heard the sound is when I looked, and it was all in a span of a few seconds. So it's, I think, fair to say that I did in fact almost see what happened.
So here, of course, the witnesses realized what is happening. So she has said, he has said that, no, of course, I could see, etc. But he was giving an explanation. And you see that even though the witness does give you that explanation, the court is going to think that what he's saying is not correct, right? Because he admits, he says, I stand by my affidavit. He says, yes, my attention was drawn after I heard the crash. So after the accident, he says, I saw the car after it hit the railing. So how could he have known whether the defendant was using the mobile phone when he was driving? Right. So then we get some sort of admission from him that he doesn't know actually. But if you ask him a direct question as to whether you know this because the defendant has told you or the opposite party has told you, you're mostly never going to get the answer because he's going to say no. It is because I know it myself. So yeah, I think that's about it.
First of all, thank you for your remarks. But I just wanted to ask that yesterday you said something to the effect of, I think while cross-examining Bhatia, that the opposite party, that only if the applicant had honked, would you have become aware of it. So that is to get him to say that, yes, he was not paying attention. So could you please, can you please repeat what those questions were? Because I didn't hear anyone asking those. So.
Okay. Mr. Singh, in your application, you have set out particulars of negligence. One of the particulars is that Mr. Bhatia did not sound his horn. Therefore, according to you, Mr. Bhatia should have sounded his horn when he was driving, isn't it? So then he said yes. Mr. Singh, you might need to answer, Pratik. So Mr. Singh, according to you, Mr. Bhatia should have sounded his horn when he was driving, isn't it?
Yes.
Yes. So therefore, according to you, if Mr. Bhatia had sounded his horn when he was crossing, you would have been alerted to the fact that the car was approaching, isn't it?
Yes.
Yes. Therefore, according to you, the accident could have been averted if Mr. Bhatia had sounded his horn?
Yes.
Yes. So therefore, according to you, if Mr. Bhatia had sounded his horn, your attention would have been brought to the fact that his car was approaching?
Yes.
Yes. So therefore, you were not paying attention while driving towards the exit, isn't it, Mr. Singh?
No, I was.
Yes, thank you, ma'am. Thank you.
I think that's about it now. So thank you, everyone. Thank you for participating. And I've had great fun with this interaction. Hope all of you enjoyed some part of it at least, if not all of it. So we come to the close of our session now. So thank you.